All right, let's dive into a fascinating legal puzzle from the early 1900s. It's a story about two court cases that look almost identical on the surface, but ended with completely opposite results. So picture this. In 1905, in a case called Lochner v. New York, the Supreme Court says a state can't limit the work hours for bakers, who are mostly men. They struck it down. But then, just 3 years later, in Muller v. Oregon, the exact same court looks at a nearly identical law for laundry workers, who are mostly women, and says, yep, this one's perfectly fine. Same issue, same court, totally different outcomes. So what on earth was going on here? What was the one crucial difference that flipped the script? That's the question we're going to dig into. And the answer, well, it tells you a whole lot about a major shift in the law and how America viewed the role of men and women. To solve this mystery, we first need to rewind and understand the world these cases were decided in. This period is often called the Lochner era, and it was dominated by one powerful idea: the freedom to contract. The big legal concept driving everything was something called substantive due process. Now, that sounds complicated, but the idea was pretty simple. The court believed the Constitution protected certain basic rights from government meddling. And back then, the most important economic right was the liberty to contract. Basically, the right for a boss and a worker to shake hands and agree to any terms they wanted without the government sticking its nose in. And that brings us right to our first case, Lochner. New York had passed a law to stop bakeries from working their employees into the ground. Seemed reasonable, right? But the Supreme Court, by a razor-thin 5-4 vote, said no. They argued that baking wasn't some uniquely dangerous job, so the state had no right to get in the middle of a private contract. And boom, that set a huge precedent. Justice Peckham, who wrote the court's opinion, really spelled it out. He said that the right to make a business contract is a fundamental part of individual liberty. Any law that tried to limit that was just, in his words, meddlesome interference. Okay, so with that strong precedent in place, how in the world did Oregon win its case just a few years later? This is where our story takes a really sharp turn, and it all comes down to what the court called the difference between the sexes. I mean, just look at them side by side. The cases are practically twins. The laws are almost identical, and the core legal question is exactly the same. The only real difference? The gender of the workers. The secret to Oregon's win wasn't some clever new legal theory. No, it was something completely different. A totally new way of arguing a case, led by a lawyer who would soon become a legal giant, Louis Brandeis. Brandeis showed up with a legal brief that was an absolute monster for its time, 113 pages long. But the real shock wasn't its size, it was what was inside. And this is where it gets wild. Look at this breakdown. Out of 113 pages, a measly 2 pages talked about the law and legal precedent. The other 111 pages, they were jam-packed with social science, medical reports, and expert opinions from all over the world, all arguing one thing, that long work hours were uniquely harmful to women. And you know what? The court didn't just buy it, they bought it unanimously. Their final decision sounded like it was ripped straight from Brandeis's brief. Justice Brewer, writing for the court, just laid it out there. History shows, he said, that women have always depended on men and simply aren't their equals in the workplace. And here it is. This is the absolute core of the decision. The court decided the state could interfere in this contract because it had a special interest in protecting women's health. But, and this is crucial, it wasn't for their own sake as individuals. It was to preserve the strength and vigor of the race. It wasn't about a woman's rights as a worker. It was about her biological role as a potential mother. Her body was now an object of public interest. So, Oregon won. The law stood. But the legacy of this decision is, well, it's incredibly complicated. Was this a win for protection, or was it just a new kind of paternalism? You see, the ruling had these two totally contradictory effects. For labor activists, it was a breakthrough. It cracked open the door for more state regulations on workplace safety, getting around that tough Lochner precedent. But for women's equality, it was a huge step backward. It literally wrote into law the idea that women were a weaker, separate class of citizens who needed the state's protection, unlike men. And people at the time saw the danger immediately. As the labor organizer Ella Sherwin so powerfully warned just a few years later, this kind of legislation could end up protecting women right out of the workforce. And she was spot on. That's exactly what started to happen. These protective laws became the justification for all sorts of things, for banning women from better-paying night shifts, for keeping them out of so-called male jobs, and even for paying them lower wages. In the end, it just made women less competitive employees. And this logic, the reasoning behind the Muller decision, it didn't just disappear after 1908, it cast a really, really long shadow, stretching deep into the 20th century. In fact, you can draw a direct line from Muller in 1908 straight to the fetal protection policies of the 1970s. For decades, major companies would refuse to hire women of childbearing age for high-paying industrial jobs, claiming they were protecting potential fetuses. It took until 1991 for the Supreme Court to finally say, no, that's just illegal sex discrimination. And this isn't just some dusty old history lesson. That core idea from Muller that a woman's body and her reproductive capacity are a matter of public interest for the state to regulate, that logic continues to pop up in all sorts of modern debates about women's health and bodily autonomy today. But there is one last, absolutely brilliant twist to this whole story. And for that insight, we have to thank the late Justice Ruth Bader Ginsburg. RBG pointed out this deep, deep irony at the heart of the Brandeis brief. The substance of the argument, the part that said women are weaker and need special protection, well, that was used to justify legal sexism for decades. But the method, the technique of using tons of real-world data to show the court what was actually happening to people, that was revolutionary. It became a powerful tool that feminists, including RBG herself, would one day pick up to tear down the very system Brandeis had helped build. As she explained it, the whole point of the Brandeis brief was to teach the judges about reality. And that, she said, was the exact same goal she and other lawyers had in the big gender discrimination cases of the 1970s. They essentially co-opted his method to argue for the exact opposite conclusion. Which leaves us with the big, timeless question that this whole story raises. A question that started with bakers and laundry workers over a century ago, and one that we are still very much grappling with today. Where exactly do we draw the line between protection and discrimination?